Dick Giuliano. I'm a lawyer in Philadelphia. I've been doing securities law my entire professional career. What I'm about to tell you is not fair and balanced. I come from the plaintiff side of the business. So for me, my job is generally bringing actions against broker-dealers, trying to enforce the federal securities laws, trying to enforce the self-regulatory rules that most customers hope exist when you have a dealing with a fiduciary, because we like to think the stockbrokers are fiduciaries. Now, as Sam pointed out earlier, when customers open up account at brokerage firms, they agree to arbitration. They agree to binding arbitration before a panel of arbitrators. And there's been a lot of debate lately, particularly in some of the periodicals, a lot of the treatises. What kind of arbitration is it? There's two kinds of arbitrations out there. There's contract arbitration, like the AAA might have, where you sign an agreement and the panel is doing nothing more than acting as a forum for those grievances. Then there's another kind of arbitration. It's called folklore arbitration. And it goes back to medieval times, the law merchant, where you would have a dispute, let's say, between two merchants, and those merchants would have someone from the industry, someone from their trade, decide the dispute. There are no formal pleading requirements or choses in action, because those were all created by the sovereign courts, when the courts created the sovereign. Instead, they would just provide the facts, the relief that they wanted. You'd have an industry person or another merchant decide the legal issues in the case. There were really legal issues. Virtually no discovery. And you would get an award or a judgment that was often unexplained. And if we look at the NASD dispute resolution process, as many commentators think, it's actually folklore arbitration. Because you've got panels who one of the persons on the panel is going to be an industry person, someone who has some tie or some connection to the brokerage industry, former branch managers, registered reps, compliance officers, someone from the industry who's bringing to the table their industry knowledge and expertise, their industry customs, so to speak. As we'll see later, the discovery rules that you folks are used to in a court, well, they just generally don't exist in arbitration. There's no ability to get depositions, for example. The only time you're allowed to get depositions was on the NASD discovery guide, is in case of an ill or dying witness or the unavailability of a witness. Until recently, the parties had the ability to issue subpoenas. Now we have to go, there's a 10-day procedure where you send a subpoena to opposing counsel. If he doesn't object within 10 days, or if he does object, files a motion to quash, you get to respond, and the chairperson of your panel issues an order instead of a subpoena. But that's